We're here this morning with Professor Catherine Grosso of Michigan State Law School. We had the honor a few years ago of having Catherine visit the National Death Penalty Archive, where she gave a talk when we dedicated the David Baldus papers at the National Death Penalty Archive. So it's great to have a chance to chat with her again. Professor Grosso worked very closely with the late Professor Baldus and has continued related work in multiple jurisdictions studying death penalty issues. I'm going to lose track of the territory that she's covered, but my recollection is it includes Nebraska, California, the US military, Philadelphia, Hamilton County, Ohio. I will talk a little bit about North Carolina. I've probably missed a few, but could you just get us started by reflecting on how you got interested in death penalty research and how you honed this very unique expertise in both legal matters and empirical matters?
Sure, it's really a pleasure. I'm a big fan of the archive and I'm glad to talk with you about it. So really, I went to law school after 10 years of human rights work, international human rights work. And it really has to be said that David Baldus is how I got into this area of work. It was his invitation to work with him as part of my scholarship at Iowa Law, and then working with him and enjoying the empirical work and the role of lawyers in empirical work. So I really got into it by accident, as so much of life happens, but it's been a wonderful path for research. I've met so many wonderful people.
Do you have what might be considered formal training in the empirical quantitative analysis, or did you learn as you go? Or?
I have a little bit of training, but I don't have any advanced training at all. We almost always employ a statistician to make sure that we're not doing something accidentally that would violate what we've learned in statistical research, our best methods. But also I always say I had a post JD from David Baldus and George Woodworth, that they patiently taught me why they thought the analytical framework they developed is one that is both proper and useful, why it's a good approach when looking at the question of the role of race or another extra legal and inappropriate factor in the administration of the criminal justice system. So I think there's new research that's gone from what they taught me, but really my foundation is in the literature, really, and in the scholars who were doing it.
Can you maybe not summarize, because we'd be here for a long time, but hit the highlights of what your investigations have revealed in these several jurisdictions that I mentioned?
I always say that at the bottom line, race matters. That's the bottom line, that anyone who asks me, race matters in how we administer criminal justice in this system. In a more sophisticated way, race matters in the selection of juries overwhelmingly and consistently. We have studied jury selection, the exercise of prosecutorial discretion in selecting jury members, peremptory strikes, right? In states all over this country. We just, we'll do one, they don't even publish. Someone will say, will you analyze this for us and see if it matters? And it's stunning to me, the pervasive influence of race in jury selection in this country. And what's hopeful to me is what the state of Washington did in reforming jury selection, and now what the state of California have done. So they both have said, we recognize that these bases for excluding citizens from serving on juries are not helpful. They're racist, and we don't need them to select a fair jury. So they outlawed certain things like demeanor. What does demeanor mean? But also so one part of my research has been about juries, and I love doing the jury work. We're doing some new work on death qualification in juries. A number of scholars are, and we're doing a little bit of that. The other line of my work looks at charging and sentencing. And, the charging and sentencing research is almost like a, a, a lens on Black Lives Matter in a way that's upside down a bit. We see in study after study that the treatment of white victims is, that punishment about white victims is more important in this country. And that's crazy. All victims should be equally valuable in our country, not some over others. So we see both under-policing in Black communities, predominantly Black communities in the studies we've done. And then we see that people who kill at least one person who's white are more likely to get the death penalty. None of that is what the law says. The other thing that I was thinking about the death penalty research that I've done as I was thinking about this talk is the overwhelming reality is that most people who are eligible for a death sentence don't get it. That even with our very sophisticated laws, we find that most cases where the prosecutor could have imposed a death sentence, the prosecutor chooses not to. 95% of the cases, 96% of the cases.
The Supreme Court's equal protection jurisprudence requires finding of purposeful discrimination. Can you reflect on the various ways that race might influence decision-making and whether this purposefulness is a criterion that the law should honor that forcefully?
Now, I've met a lot of prosecutors over the years, and I have never known a prosecutor who would purposefully discriminate. Maybe they're hiding from me, but the people I know are horrified that they are purposeful. They say, we try to treat everyone fair. This crime is a bad crime. But when we look systematically across cases, we can see that even though no one intended there to be discrimination, there's more punitive treatment in some cases than others, that people, limiting the cases to those where there's purposeful discrimination puts a blind eye to the way the system itself is skewed.
And that's part of the reform, if I'm remembering correctly, that the Washington Initiative tries to cover, that there's much less emphasis on intent and more on result and what an objective observer would be able to conclude.
Yes, both Washington and now in California. I mean, the California Racial Justice Act is remarkable. I mean, it's not just for capital cases, it's for all levels of the criminal justice system. It does not require evidence in this case. It requires meaningful evidence, significant evidence that in any way shows that race was important.
Let me ask you to expand a bit about the importance of juries in capital cases. In the death penalty context, juries perform what's almost a unique function of sentencing, and in almost all other cases and almost all jurisdictions, judges impose sentence. But in death penalty cases, it's the jury. And why is it that we rely on juries to impose death or life sentences? And I'd like to follow up with some of your North Carolina work in terms of the importance of jury decision making and whether we are seeing sentences that are imposed by a jury of the defendant's peers. So first, why do we value juries in this context? So
I really think you have to turn to the Eighth Amendment to understand why we allow juries in this part. The Eighth Amendment prohibits cruel and unusual punishment, and the Supreme Court from the earliest days of this country have said that the way we know what it means requires that we have touchstones in the community, that we look at the evolving sensibilities of our citizens. And the jury is one of the ways that we make sure that that this particular death sentence is proportionate and fair in the eyes of the community. So you need a jury that is reflective of a fair cross-section, and that is, research has shown that having diverse voices, I'm racially, but otherwise too, diverse voices in the conversation helps the jury make a better decision and a more grounded decision, one that holds up. So it's both for practical reasons and for constitutional reasons that we have asked juries to apply, to use the law to figure out whether the facts in this case merit a death sentence. But what we found in North Carolina, where we've done the most sophisticated and exhaustive, we still do. We are still researching in North Carolina, and we keep finding that prosecutors expend a great deal of energy to excuse Black jurors because using, I imagine, unsophisticated stereotypes about what Black people think, right? You're hard pressed to think that all Black people are soft on crime, right? This is silly. But we see again and again that maybe a slight improvement in very recent cases, as we keep saying, stop doing this. This is not fruitful for you. But we see that juries tend to be, an all-white jury is still not unheard of in a diverse state where it's possible to see a more diverse jury. So we worry. We want to see, and also the National Center for State Courts has continued to do incredible work trying to help states do a better job of reaching all of the citizens, right? To try to help them so that a jury summons comes to everyone and finds them, even if they have to move more often because of their economic fragility, or because they're students and they change their address every 3 weeks. That we figure out how to use the modern technology and the best thinking to summon everybody. And I think if we can do that, and then we can maybe encourage the attorneys who are involved to believe a little bit more in the likelihood that chance will serve them well, right? In England now, you get what you get. You don't get peremptories. And I think that most attorneys, most trial attorneys, prosecutors, and defenders who I know won't even let me finish the sentence if I want to get rid of peremptories. But I think we could have just a couple, not like a dozen or more, which is so often the case in capital cases. Let's assume more of our citizens. Let's tell our citizens, come be on the jury, bring your best self, set your biases aside. It's like, this is going to sound crazy. You can delete this part if you want, but I was an election inspector in the state of Michigan. I worked the polls, and everyone I know who worked the polls has great confidence in the system. We saw the nitty-gritty of it. We saw how much replication there is. And I think the same is true, and I know it's true from research that's been done. When people serve on juries, they feel more confident about the system. It helps our democracy. It's our second most, the second touchstone, the second opportunity we have to participate. So I think we should keep the state, that's the prosecutors, and also the defense, but really the state, from excluding jurors from serving, and we should encourage people to want to serve. Nobody I know wants to serve on a jury. They don't even tell me when they get their summons.
Serving on a jury in a death penalty case imposes quite a obligation on citizens. That's for sure.
Even not death, even if it's just a serious felony, it's a couple weeks. I mean, it's hard. It's a lot.
Right. And the weight of that moral judgment is considerable, especially when we're making sentencing decisions now. But what about, and then we'll, if the jury is important in capital cases sentencing because it is to reflect the collective moral wisdom judgment of the community. You mentioned that we need to do a good job of comprising jury pools, the veneer, the grand bulk of people who are called to jury duty. And you spoke about the peremptory challenges, but then you mentioned earlier the cause challenges. Now, can you explain what those are and how they affect the judgment of the community and why why cost challenges are recognized?
So always, as long as there have been juries, there's been permission on the part of the judge or any of the parties to argue that one of the people who's been selected to serve on the jury is too biased to be fair. Usually that means they know one of the parties, right? They're related to the defendant or the prosecutor. But in death penalty cases, it's a whole different thing. In death penalty cases, it's come to be the law that if you oppose or have serious concerns about the death penalty, you can't serve on the jury because the thinking goes you couldn't uphold the law, which allows the death penalty. So as more people have come, the popularity of the death penalty is as low as it's been in my lifetime right now. And as fewer people support the death penalty, the challenge to select a fair jury has gotten harder because more people are excluded because they oppose the death penalty. So what's left is a skewed cross-section of supporters of the death penalty, hopefully some who support it less and none who support it too much, right? It's a crazy process. And I think the Supreme Court say, well, it's unavoidable as long as the law allows the death penalty. But, you know, scholars a long time ago said, let's at least, or litigants maybe said it, don't want to give scholars too much credit, said, well, then let's do the guilt phase with everybody. Let's find out if this guy's guilty with all of the citizens. And then maybe when it comes to weighing the death penalty, we can't include people who would never impose and have a unanimous requirement. But still, it marches forward.
It's a paradoxical situation, isn't it? When you want the sentencing decision to reflect the moral sense of the community, but there's a systematic purging of those who are strongly against the death penalty. But as you said, that has been the law and probably will continue to be the law as practice. Well, the research you have done has just been eye-opening in terms of demonstrating how the death penalty is administered in practice, how frequently it doesn't resemble very closely the way we map it out on paper. Have you any future projects in the hopper that you could briefly mention?
Yeah, so I am working a lot on the California law to try to help implement. It's difficult to implement a new law that's as broad as the California Racial Justice Act. So I've been trying to help lawyers think about what the research might look like to support claims. So, and those will be pretty classic charging and sentencing type claims, and also some jury claims, which is good. So I think there'll still be claims. We've also continued, I think it's really important, you know, Anthony Amsterdam said maybe 10 years ago now, we need to go local. We need to help people see what's happening where it matters. And I think the lawyers responded amazingly to this. And so you see like prosecutors who got elected who say they're concerned about the death penalty. You see concerns about the death penalty raised as part of the election campaign in Cincinnati. Like in Cincinnati, the longtime prosecutor was challenged. He didn't win. The opponent didn't win, but the longtime was challenged about whether this is the best approach, the best use of our resources. So I guess I think that, and even in the California design, I think that we need to think local. I think we need to look for multiple kinds of ways, multiple kinds of evidence that help us understand the influence of race, the influence of inappropriate factors. Why is it that everyone on on death row is Black? Like why? Why? So I think that there's lots of research to be done. There's more than I could ever do. I think that we are always so glad when someone calls us up and says, hey, listen, we've got this little bit of information. Can you help us understand what it is? Can we talk about ways we should do it better? What can we collect? What should we know? The Hamilton County Project is a great example of just lawyers who had partnered with other organizations to do some of the historical research on race in Cincinnati. and then asked us to do the empirical work on the decisions, looking closely at the decisions. And it was just fun to do.
Well, I don't know how you do all that you do, but keep doing it. We would love to get you back to the Death Penalty Archive some great day. Thank you for everything you've done and for the chance to share a little bit of that today.
It's really my pleasure. And I have to tell you that I am, as I said at the beginning, a big fan of the archive. I believe that having good archives is really important. So I'm always telling my colleagues that they need to preserve their research. They need to think about electronic research, and they need to figure out how to get it to the archive. So thank you for all the good work you've been doing.